Welcome back, everyone. Thanks for sticking around. That means a lot to everybody. And you're going to be really, really, really glad that you did, because we have something very different today. We have a regulatory spotlight. So and this is on the SEC. And it's rare that you get somebody. Why is this such a big treat? Because first off, we have Arsen Ablaev, Senior Counsel in the Cyber Unit of the SEC's Enforcement Division, who leads investigations and litigates cases across the country to enforce the federal securities laws with a focus on cyber technology and even digital assets. Those functions were combined last year into this specialized group. So Arsen is really smack dab in the middle of an incredibly growth area. I don't know, Arsen, if that group has grown to doubled in size, but certainly the biggest specialized group that there is. And you got to be multi-talented, multifaceted. He's got a bachelor's degree in software operations, 5 years experience as a software developer. This is the new SEC, technologically locked and loaded and ready for battle, which they have to be, because the investigations and litigations have become enormously complex. The rulemakings are constant. We love to hear from directors and chiefs, but I also love to hear from people who are on the front lines where the action is. Arsen is a high-tech Columbo, Joe Friday, and Kojak all in one. So we could not be more thrilled. Welcome, Arsen.
Thanks very much. Thanks very much. Appreciate the opportunity. You forgot to say that I speak Russian.
Oh my gosh.
And I'm learning Chinese. Right. I'm in the right spot here.
This is great. When you read the SEC briefs and some of the ones with Arsen's name on it, you will recognize them as poetry, which is really interesting. So who do you get to interview someone like Arsen? Well, you get Travis LeBlanc, the chair of Cooley's cyber data privacy practices, who really thrives amid this juxtaposition of cyber technology, law, and business. And you'll note from his bio his extraordinary level of government experience, chief of the FCC Enforcement Bureau during the Obama administration, a lawyer in the California AG's office, where at the direction of then California AG Kamala Harris, launched California's statewide privacy enforcement and protection unit, first of its kind, as well as the California e-crime unit. And you'll also note, of course, that Travis is one of the few people on the planet who has degrees from Yale, Princeton, Harvard, and Cambridge. Yes, all four. It's so annoying. You may miss that the U.S. Senate unanimously confirmed twice Travis when he was nominated to the Privacy and Civil Liberties Oversight Board by former President Trump and President Biden, which advises on and reviews the federal government's counterterrorism activities to safeguard privacy and civil liberties. I can't wait for when I see Travis on Air Force One and I tell my kids I knew this guy. I've had the privilege of working with Travis on a few matters. His brilliance is only outdone by his humility. I like to say that Travis is sort of like the Joel Embiid of IR because he towers over everyone else. But it's really the other way around. Joel Embiid is the Travis LeBlanc of the NBA. So let me turn it over to you, my friend Travis, and I can't wait to listen to this real-time discussion about what's going on.
Thank you so much, John. That is an extremely generous introduction. And let's be honest, it's why I continue to come back every single year just for the intro before we ever get to the content. But it really is a pleasure to be back at the Incident Response Forum Masterclass in 2023. I am delighted to be here today for this spotlight on the SEC, along with Arsen Ablaev, who is a senior counsel in the Crypto Assets and Cyber Enforcement Unit at the SEC. We only have 25 minutes with all of you today, and we have a lot to cover. So I'm going to jump right in. But I did want to note that I'm monitoring the chat. If you have any questions for Arsen, please feel free to put them in the chat. I'm sure we won't be able to tackle all of them in this session, but I'll try to include as many of them as I can. Additionally, in the interest of expediency, I'll also note that Arsen is here in his personal capacity. Any of his comments today do not reflect the views of the SEC or any commissioner of the SEC. In short, please don't quote Arsen in any regulatory filings. I assure you they will be swiftly rejected. With that, let's jump in. Arsen, as I'm sure you can appreciate, numerous federal and state agencies are all concurrently pursuing enforcement or rulemakings in the cybersecurity space. Many perceive the SEC to be a new federal player in the cyber regulatory and enforcement table. Is that a fair perception? What are the SEC's cyber enforcement priorities with respect to issuers and regulated entities? Are there any recent SEC enforcement actions that you would highlight?
Hey, thanks, Travis. Great question. I think my first cyber case that I filed was the SEC was in 2018. The cyber unit was really kind of getting off the ground. At the time, it was called the cyber unit. Now it's called the crypto assets and cyber unit. Before that, there was really, not a whole lot of SEC enforcement activity in cyberspace. But I think, 5 years of, really very clearly increased activity, I think is, I think it's, I think we're past the point of saying that we're a new player in this area. I do acknowledge, though, there's definitely room to grow, and I expect that we will continue to grow in that space. On enforcement priorities, we in the Division of Enforcement really do take cue from our clients, the commissioners of the SEC, and a good way to get a sense of what their priorities are in this space specifically is to take a look at the recent slate of rule proposals from the SEC in the cyberspace specifically. It's I think a good way to get a glimpse into that. And in broad strokes, first I'll note that the rules are not final yet. There are 5, I think, that are cybersecurity specific. They're not final yet, but I think they do give folks a view into what the SEC generally and Division of Enforcement more specifically is going to be interested in the coming months and years. I think you can break the sort of the priorities into these few categories. I think flow of information is very important, and when I'm talking about flow of information, I'm talking about internal flow of information. That's from the CISOs, from the techs, up to senior management, executive management, the board. I'm also talking about flow of information going in externally outside of the company to the investors. Related issue on that you will see, really covered in the rulemakings and proposed rulemakings is, the need for additional involvement and oversight by senior management, executive management, and in some cases the board in both cyber hygiene and incident response. And then finally, another sort of thread that is common to the rulemakings is better documentation, better record keeping of documents and records related to again both cyber hygiene and incident response. So let me pause here, see if you have any Travis, any follow up, or we can move on to the next question.
No, look, let me assure you, corporate America is, and especially public companies and aspiring public companies have been paying and are paying close attention to the SEC's rulemaking on cybersecurity risk management, strategy, governance, and incident disclosure by public companies. And as you noted, this is just, one of 4 or 5 cyber rulemakings that the SEC is undertaking right now. But do you have a sense of the timing of the finalization of the issuer rulemaking? Some have suggested it may be finalized this month. Should we expect to see a final rule in April?
Yeah, so I can't speak as to timing other than saying that, April is really, really unlikely. So generally, a final rule will have to be put on the commission calendar for an open commission meeting. Generally you will see a notice of that meeting a week out before the meeting. There hasn't been one scheduled for this month for April. But I would recommend folks to keep an eye at the upcoming events page on the sec.gov website.
All right. So we'll take that as a no for April, but keep checking the website. One of the issues that many public companies have been considering is how to manage disclosure of material cyber incidents during the middle of an incident or when the company does not have full information about the extent of the cyber incident. It's often the case that what a company knows on day one of an incident, what it knows on day 15, can be totally different and possibly even contradictory. So many companies are worried about having to do mid-incident reporting to the SEC that would be public. And this is especially concerning if the vulnerability has not yet been resolved or if the company is cooperating with law enforcement. How do you address the critics who say that mandating an early SEC disclosure puts companies at risk of making a premature disclosure through an 8K that can undermine the company and law enforcement investigations?
Okay. Yeah. Excellent question. I think it's fair to ask the question, but I also think, I think at this point there are lots of examples out there of both publicly traded and private companies doing exactly that, what you just described, which is providing, transparent and open information about an incident to the investing public or to the public more generally, once they conclude that the incident was material, and then sort of updating that information as they come to additional relevant information in the course of an ongoing investigation. I think it's a really important question because I think there is a certain mystique almost to cybersecurity that sometimes it feels like when you're reading coverage of cybersecurity incidents, it seems like you're reading noir fiction of some sort, but which I think is really it makes our space really interesting and fascinating and brings a lot of attention to our space. But I think it also makes it difficult for people in the space sometimes to see the more mundane aspects of it. And I think 5-6 years ago, I think you heard that argument, or at least I heard that argument a lot more frequently and from a lot more people about how sort of interim disclosures about cyber incidents are hard. They're difficult to do. But I think now, you see a lot more folks who sort of figured out that it's not that much different from providing interim updates on other things that affect a corporation, like an M&A transaction or internal investigation into potential accounting discrepancies, really anything that could occur to a corporation. It's not that different from that, from those things where also information can develop in unexpected ways over time. One thing I'll note, is a real sort of compliment to this forum. Really appreciated folks talking about, in particular, it was Evan Roberts from FTI talking about a shift that he was seeing away from the traditional in the bunker approach to external communications on these cyber incidents and towards a more transparent approach. I think I'm also seeing that amongst issuers. I think other folks are seeing that at the SEC as well. On the second part of your question, again, that's a really important question. It is something that I still hear very frequently in the course of our investigations at the SEC about the sort of risks that the companies take on by providing early disclosure. And so, again, this is something that I hear frequently from counsel representing companies in our investigations. but I've yet to see that risk materialize in real life. And I'll give you an example why I think it's unlikely that early disclosure of a cyber incident is unlikely to lead to significant additional risk. If a company is describing an intrusion to the investing public and is telling at the same time the investing public that its cyber protections are strong and are in place and are functioning, without disclosing, for example, that the hackers in that cyber intrusion used a long unpatched critical vulnerability. That's a problem from our perspective. So if you look at it, for example, the Pearson case that we filed in 2021, that was something, that was a factual scenario that we dealt with. That's a problem. But did we then go and, expect the company to include in its disclosure the IP address of the server that was unpatched at the time and the CVE number of the vulnerability that was unpatched in that disclosure? No, of course not. And I think you can, take a look at the 2018 guidance from the Commission on Cyber Disclosure. Very clearly said, we do not expect issuers to be providing a roadmap to the hackers in their disclosures. But you have to provide enough information for the public, for the investing public, to understand the other information that you're providing about the cyber incident. I'll make another point on that before I forget. Sorry. If by the time you're making a disclosure about a cyber incident, you still have the server or the computer that was unpatched, still unpatched and still available to the internet, there may be a different problem that you also have to deal with than the disclosure.
Yeah, we got a question from the audience, Arsen, which is, let's suppose that there's a public company who uses a third party for data hosting or access, and the third party has a breach, of the company's data. Is there a duplicate reporting requirement? In other words, do both have to report the breach, or is it okay if just one of them reports the incident? I imagine this comes up because often at the state level, when we're looking at it, you're thinking about, the data breach notification requirement, and typically just one of those entities would report it, and you wouldn't have everyone in the entire series reporting it. What do you think about that?
Yeah, good question, fair question. Assuming both entities, the service provider and the sort of the data owner, are publicly traded companies, I think they individually will have to decide whether the breach is material to them. So to the service provider, if the breach only involved one of their customers, that, I could see a situation where, the breach may not be material to them, so they might not have to report it out publicly. But if it's material to the owner of the data, they should disclose it. If it's material to the service provider, they should also disclose it and provide information to the investors why it's material to them. How does that particular breach affect that company? That's why, both should disclose it if it's material to both of them, so that the investors in both companies are aware of the event and why it's material to them.
And so let's suppose we now find ourselves in that scenario where the third party gives information about the incident, right? The hosting company, the service provider there. And that information is all the owner can rely upon when actually making a disclosure. And let's suppose there's an error in there. Is there room to make updates or amend an 8K or other SEC filing to correct for that? Or do we just own the mistake of the service provider?
Yeah, there is absolutely, there's currently, several mechanisms for updating and providing information to the investing public by the issuers. And you can do it in an 8K, on a sort of an irregular basis, ad hoc basis. You can amend that 8K later with Form 8KA 8K amendment. You can also provide this information in periodic reports and quarterly and annual reports. So, absolutely, you can update. You should. And, again, this is a situation that comes up at this point fairly frequently, and you can see filings by intrusions updating their prior filings or providing updated information from what's publicly available, at this point on a regular basis.
Okay. Look, many public companies have also been wondering about how to determine materiality in the cyber context. Is there any guidance that you might highlight to assist with how to determine the materiality of a cyber incident? And importantly, how should companies assess when a series of immaterial incidents rise to the level of materiality for disclosure purposes?
Yeah, great question. Yes, absolutely. There is guidance. I would just start for materiality from the basic principle. Is there a substantial likelihood that a reasonable investor will find the information that you're talking about to be important in making an investment decision? And that investment decision can be buying or selling or holding a particular security. So there is, in the 2018 Commission guidance on cyber disclosures, which is available on the SEC website. There actually, I went back and take a look at it on pages 3, 13, and 14. There is actually a very good list of non-exclusive. We always like to say it's non-exclusive factors for in the cyberspace for companies to consider when they're trying to figure out if something is material or not. I'm not gonna spend time going through the factors here. I'll note, from my perspective as an enforcement attorney, and I know that looking at our recent cases, you'll see this another through line: the reputation factor, the harm to the reputation of the company is something that gets kind of a short shrift currently, at least from our perspective, with the issuer. So it's very important to assess what kind of harm to the reputation of the company this incident might have. And I would point to the Pearson matter from 2021 and also the Blackbaud matter that we filed this year. On the multiple immaterial incidents question that over time become material, really good question. I think the CISOs and the management, should be thinking about whether, when they see multiple incidents occur, whether there is a unifying characteristic, some characteristic that relates these incidents together. Usually what might relate incidents together might be the same threat actor coming back and continuing to attack the company successfully, or it could be the same vulnerability or weakness that is being exploited. If that happens over time, that series of incidents may, even though each incident itself might not be material, the series of incidents that is related may become material and may require disclosure.
Bill, thank you very much for that helpful background and pointing us to that guidance. Recognizing that we don't know when the issuer rulemaking will be finalized, what should public companies do now to ensure that their cyber risk management practices are in compliance with existing law and that those companies are prepared for the anticipated final rule?
Yeah, good question. I would say, the current rules for cyber really do focus on disclosure. So even if you look at the proposed rules, the proposed rules that are talking about risk management strategies, they are still talking about it in terms of disclosing what the risk management strategies are to the investing public. I think there are a couple of rules that are important for folks to keep in mind that do directly deal with I think risk management. And that's the rules around internal controls. That's Exchange Act Section 13B2B, and disclosure controls, Exchange Act Section 13A. I see Bruce coming on. I would recommend folks to take a look at Section 21A report of investigation from 2018 to get a little bit more color on those two sets of rules.
Arsen, thanks so much. This was awesome. We touched on a lot of issues that I know are critical and that a lot of public companies are thinking about today. Appreciate the conversation. Great to see you. And Bruce, thank you for another great conference.
Thank you, Travis. Thank you for another great moderating job. And Arsen, as always, terrific. Really appreciate hearing from the SEC. Really important for this group in particular. So thank you. We'll be back in 5 minutes for the announcement of the Incident Response 50 list for 2023. See you at 5 p.m.